Good afternoon, everyone. My name is Jeremy Herman. I'm an employment lawyer with Samfiru, Tumarkin, LLP. It's great to be back with you. I've hosted many of these question and answer sessions in the past couple of years. It's great to be back for a new year of sessions. I'm looking forward to lots of good questions and providing employment law advice. As you know, we have offices across all of Canada and several provinces. We have offices in Ontario and in Alberta and British Columbia. I work out of the Toronto, Ontario office. Before we dive into questions, as I usually do, I like to start off these sessions with discussing an important employment law topic. Or providing some sort of update that's been happening in the work industries that are impacting people's jobs. And so this session, I want to start off by discussing the layoffs that are potentially happening at Salesforce. Salesforce is a massive tech company. And there are going to be approximately 1,000 jobs slashed. It's unclear exactly whether that will impact Canadian employees, but it very well might. And it's important for all of you to know what happens if you're terminated or laid off, what you should do in those circumstances. And obviously, we've seen many layoffs in the tech industry in the past couple of years. So it's not so surprising that amid AI developments, et cetera, there are layoffs happening or continuing to happen in the tech industry. So what to do? First of all, understand what your compensation rights are. If you are terminated or laid off, even if it's as a result of difficult financial times for the company, you're still owed your severance pay. Your severance pay could be as much as 24 months of pay. And it will depend on your particular circumstances, right? How much you're owed. But it could be as much as 2 years of pay, which is very substantial, of course. Another thing to note, and I get asked this every day. I speak to employees who are laid off every single day, and I'm always asked the question, I have a termination letter, there's an offer, a severance offer in that letter, and there's a deadline. The company wants me to send back a signed copy of the termination agreement by Friday, a few days from now, or it could be 10 days from now or 20 days from now. And what I always tell people is that those deadlines don't matter. It's a pressure tactic that employers use, and all employers do it. And they're always in termination letters. There's always a deadline, and it's to put pressure on you to accept the offer, the severance offer that the company wants you to accept. Usually that offer is going to be below your entitlements, sometimes well below what your actual entitlements are. So do not succumb to that pressure, even if it's past the deadline. You do have a deadline to pursue your entitlements, but it's not the deadline that the company is arbitrarily including in their termination letters. And that's why we see all sorts of deadlines. We see 2-day deadlines, 10-day deadlines, 20-day deadlines, because they're made up. The employers are making them up. You do, as I mentioned, have a deadline, though. Your deadline is 2 years. You have 2 years to pursue your severance entitlements by way of commencing a legal proceeding. And so you do want to act quickly. You don't want to just sit around and after you've been terminated, not do anything about it. You want to act quickly. You want to contact our firm. You can contact me directly or anyone else at our firm. You can contact us at help@employmentlawyer.ca, and we will assist you as quickly as we can to ensure that you are provided with the appropriate advice and to seek out your proper severance entitlements. If you sign the offer, there's very little, if anything, that we can do for you. So do not sign the termination agreements. Have them be reviewed by myself or another employment lawyer at my firm. Okay? And remember, you could be owed as much as 24 months of pay, depending on your circumstances. And those circumstances in general are your age, your length of service, your position, how much money you made, your remuneration, that is, and generally how available similar jobs are in the industry that you work in. Okay, those are the factors that are used to determine your severance pay. And so each person's severance is different. For some people, it could be a couple months. For some people, it could be 10 months or up to 24. So it depends on your circumstances. Contact us and we can help you assess what your entitlements are. One last thing to talk about before we dive into questions is our severance pay calculator. Sometimes I raise this in the middle of the session. At this point, I'm going to raise it in the beginning of the session because we're talking about severance and how much could be owed. So the appropriate tool to use is our Pocket Employment Lawyer. You see it on the screen, pocketemploymentlawyer.ca. There's a severance pay calculator, and it will very easily determine for you how much severance you're owed. All you have to do is put in those things, those factors: your age, your length of service, your position, your remuneration, and the Pocket severance calculator will tell you how much you're owed. Okay, it's going to give you a range of your severance entitlements. You should use this tool. Use it if you've been terminated. Use it if you haven't yet been terminated, but you're just curious to know how much severance you would be owed in the event that you are terminated. Share it with your friends and family. It's free. It's anonymous. So use it to your heart's content. All right. Well, with all that said, let us jump into questions. So, we have a question on YouTube from Corrine. My employer just called us into a last-minute meeting to let us know we are all being let go and they were filing for bankruptcy. I've worked here for 4 years. Are they really allowed to not pay out any severance because of this? How do I find out if they actually filed for bankruptcy? Okay, so usually if there's some sort of bankruptcy proceedings, you're going to be notified of that formally. You'll be notified of that by either the trustee or some other entity that will advise you that the company has filed for bankruptcy and what your rights are and what next steps look like. So that's the way you would know. You could also do generic searches online. Sometimes that will give you information that's relevant and helpful. In terms of what you're owed, if your employer is in fact filing for bankruptcy, it doesn't extinguish your severance entitlements. You are still owed what you're owed. But the reality is that it will probably be quite difficult to obtain those entitlements or all of those entitlements. Maybe you could obtain some of them, but not the full extent of your severance. It really depends on the scenario. But that is what's operating here. It's not that you're not owed your pay anymore, but it just becomes a more difficult process to obtain the compensation that you're owed as a result of the bankruptcy. Good question. We do see this somewhat often. Hopefully it's not too often because we don't want companies filing for bankruptcy, of course, but it does happen in my practice, and it's an unfortunate scenario for everyone, for the company, for the employees. So I hope that was helpful, Corinne. If you have a follow-up question, feel free to ask. So let us move on to a question on YouTube from Rare Butterscotch. I work for a private company that helps people with disabilities. I was originally hired as a caregiver, but then later I signed a contract to also work as a program coordinator for 2 days a week while continuing as a caregiver for the other 3 days per week. Despite this, my hours and pay haven't changed. How can I make sure I get the pay and rights I signed for? Well, it's very clear. If you signed a contract that says you get a certain amount of money and you're not getting it, then it's a contractual breach. The company has breached that contract, and you can start by contacting us, and we will send a letter to the company to try to get what you're owed, ensure that from here on out they are paying you what you're owed as per the contract. And if the company continues to fail to pay you what you're owed under that contract, then you can commence a legal action. In other words, a lawsuit against the company to ensure that they give you what you're owed pursuant to the contract. Let us look at the contract first, because maybe there's some terms in there that you don't quite understand, and we can help you understand those terms. So that's the first step. Contact us. You can contact us again at help@employmentlawyer.ca. Let's arrange a consultation. I'll review that contract for you, and then we'll go from there. Okay. Let us move on. We have another question on YouTube from Redmayne. I've worked multiple shifts, but have still not been told whether I'm officially hired. Before my third shift, I asked again over the phone about being added to payroll, and they reassured me that they were keeping track of my hours and would add me to the system. I also asked in person during the shift, and they gave me the same response. Should I wait and see how it plays out, or is this a major red flag? I'd say that's a major red flag. If you're working for a company in exchange for pay. That's how it works in our labor economy. So if you are providing your end of the deal, so to speak, you're providing the services to the company through your employment, and they're not paying you for it, then there's an issue with the employment relationship, and I would see that as a red flag. You might want to follow up again, but I wouldn't continue working shifts if you're not being paid for them. Yeah, definitely a red flag there. Okay, so if you just joined us, I'm Jeremy Herman. I'm an employment lawyer with Samfiru, Tumarkin LLP. I'm answering employment law questions at this time, so feel free to ask questions, post them in the chat, and I will get to them. Let's move on. We have a question on YouTube from Miss Swat. I went on maternity leave, and during that leave, my position as an HR generalist was given to the temporary person hired to cover my position. She was given my job. It was communicated to me that a new role would be created for me upon my return. I communicated with the new HR manager, and several of the jobs outlined for me were pushed off or delayed. As of yesterday, my role was terminated. They cited a lack of things for me to do. They're offering 6 weeks of pay plus 2 for the hardship. After 8 years, I thought I'd be given more respect. What can I do? All right, absolutely contact us because there's several issues here. First of all, if you're on parental leave, you are supposed to be given your job or a very similar job if your job is not available anymore upon your return. So that is one issue. You can't not be given the same job or a very similar job when you come back. The second issue is that if you're terminated, and they're offering you only 6 weeks of pay, depending on what your employment contract says, that's not going to be enough. Right? If you work there for 8 years, you're definitely owed more than the 6 weeks of pay. You might be owed much more than that, and that will be based on what your employment contract might say upon termination, what your severance entitlements are. So I have to review your contract first. But what I can say is very likely you're going to be owed more compensation as a result of losing your position, as a result of not getting your position back from returning from the parental leave. And you can definitely do something about that. So contact us at helpandemploymentlawyer.ca. We'll arrange a consultation. We'll review the relevant documentation. We'll gather more details from you, and then we will represent you if it's appropriate to do so, and we'll get you the compensation that you're owed. Okay. Let's move on. If a coworker is this is a question on YouTube, rather, from Dominic. If a coworker is repeatedly falsely claiming harassment in order to get you fired, would this be a case for defamation? Yeah, but potentially. I mean, I don't practice that kind of law. I practice employment law. This is somewhat related to employment law, but defamation is not in my area of expertise. But what I could tell you is that if they're false claims, you can prove they're false claims, then you might have a case there, and you should reach out to the appropriate lawyer for that. In terms of other remedies within the realm of employment law, you should certainly contact the company about this if you haven't already, and you should let them know that you believe these claims are false, why you think they're false, supply any evidence you might have. gather all this evidence and make sure you keep a record of it, because it could be you are going to be let go. You might be terminated as a result of these claims. You might be terminated without even severance pay if the company really believes that these harassment claims are valid. So make sure that you gather your documentation, gather your evidence to ensure that you're well equipped for any sort of termination or legal action. This is probably a good time to talk about a termination for cause, because this might apply potentially to Dominic's situation. So if you're terminated for cause, it means that your employer believes that they have grounds to terminate you without severance pay. They think that you've engaged in something really bad, really egregious, willful sort of misconduct, that you're not owed your severance pay, and they can let you go right away without it. I see cases like that all the time. Very often the employer is terminating an employee for cause, and there isn't actually cause. The employer believes that there is, or is really just trying to get away with not paying severance, but there really isn't cause according to the law. And in that kind of case, you're absolutely owed your severance pay, and we'll help you get it. Sometimes, of course, could be that the employee really did engage in the misconduct that the employer is saying they engaged in, and it was serious misconduct, and they wouldn't be owed their severance because there is cause for termination. So if that happens to you, if you're terminated for cause, don't think that you don't have any rights. You do. Still contact us, and we'll review the case in detail to advise you whether we believe that your employer really has cause for termination or not. And if they don't, we'll help you get your severance pay. Okay? This is a very common thing. So let's move on. We have a question on YouTube from Professional AD. I have been with my current company for just over 5 years. I didn't sign the previous contract as I cannot agree to a clause regarding any severance I would get if let go. We have new owners, and they've put another contract in front of me with a similar termination clause, and they say after we sign it, we'll receive a $500 bonus. Do I have to sign the contract? Can I just say no? I don't feel comfortable signing it. If I don't, I assume if I don't sign, I assume I would then be employed under the regular terms. Yeah, good question, and this is very common when there's a new owner that's coming into play, and they're taking on the employees of the company that they purchased or took over. It's very common for that new company or new owner to offer or request rather that the employees sign new employment contracts. Usually you don't have to sign a new employment contract if it's being offered to you in the middle of your employment, right? And often those contracts are not going to be valid if they're just if the company is just requesting that you sign it. If they're offering you a bonus in exchange for signing it, that is a way to make the contract valid. The employer is trying to give you something of value in exchange for signing the contract. You don't have to sign the contract. It could be that the company will say that you are resigning your employment if you don't sign it. I've seen that happen before. That would be problematic because it isn't resigning your employment. You are just not agreeing to the new terms that you didn't have in place with your employment previously. And you don't have to agree to those new terms. So you can go on, tell them you're not signing the contract, and try to work under the existing terms that you had with the previous owner. Now, it could be that as a result, the company, the new owner, terminates you. If they do terminate you, then you're owed your severance pay, right? It's no different than being terminated if you were never presented with a contract. You'd be owed your severance pay if you were let go in that case, and you'd be owed your severance pay in this case if you are let go because you didn't sign a new contract. So your severance rights don't change in that case. And in general, this is a good segue into the discussion of constructive dismissal. Constructive dismissal is similar to this situation. It is a situation where an employer is asking you to accept new terms of employment that are substantially different than the employment terms you had previously. So it could be a new employment contract. It could be that your employer is saying that they're going through financial troubles. They need to reduce your pay, right? You're earning maybe $100,000. They need to reduce it to $70,000. That would be a type of constructive dismissal. It may not be pay. It could be your hours. It could be your duties. All sorts of changes that are to your employment. Those would all be illegal. You don't have to accept those changes, and your employment is considered terminated, just as if your employer actually terminated you, sent you a termination letter, and offered you severance. So if you're in that kind of situation, you're getting a new employment contract presented, you are being told that they're going to reduce your pay, they're going to reduce your hours, or your duties are going to change significantly. Let us know, and we will help you and advise whether or not you have rights in that situation. It could be that your employer is able to implement some changes if your employment contract permits them to do so. So as usual, the first step is to review your employment contract. Once we've reviewed it, we'll get a good sense of whether these changes that the employer wants to implement are legal or not. Often they're not. The employment contract does not permit the changes to be implemented. And in that case, like I said, it's a termination, and we will help you deal with how you end your employment with the company and seek your severance pay. Okay. Constructive dismissals are super common. I just had a thorough consultation today with an employee who believes they're being constructively dismissed. Their salary was being cut tremendously, and that's not legal. Okay, so we'll help you in those kinds of cases as well. At this point, another important topic that we should address is the topic of, given that we're in the winter, if you're let go due to bad weather, right? You're trying to get to work, you're missing days at work potentially, or you're just coming really late because you're stuck in a snowstorm and you're trying to commute and you're having troubles with that. We've seen these kinds of cases, and usually every single winter they occur. And if that happens, if your employer is letting you go because they say that you have been late because of bad weather or whatever the reason might be, even if it's not because of bad weather, they just don't like that you've been late regularly, then if they let you go without cause, then it's the same as being let go for any reason. You're owed your severance pay. Again, it's based on your age, your length of service, your position, how much money you earn, and that's how your severance will be determined in that kind of situation. If your employer is trying to let you go for cause, where they're trying to withhold your severance pay because you are late, right? Then in that scenario, you are likely still going to be owed your severance pay. In order for your employer to show that they have cause for termination, in this case, they're going to have to show that you could have actually done something about it. It wasn't completely out of your control. You could have, got to work on time despite the bad weather. And they'll also have to show that they engaged in progressive discipline, which means they sent you warnings. They sent you written warnings. They clearly told you that you can't come late. And you nevertheless were coming late over and over and over. Then in that case, potentially your employer might have cause for termination. But in many cases, they don't, right? They really have to engage in the proper discipline procedures in order to get away with terminating you for cause. Okay. And that's if it has to do with bad weather or any other potential reasons why the employer believes that they want to let you go with no severance pay, right? It could be attendance issues. It could be that they think you're bullying someone at work. It could be that they believe you've stolen from the company or you've breached some sort of policy. Any of those kinds of reasons that the employer is relying on in order to let you go without severance, the employer is going to have to prove it. And the employer will have to show that they engaged in all of that discipline, those disciplinary measures. Sometimes it might entail a suspension, sometimes not. And then in that case, there might be cause for termination. But, we see these kinds of cases all the time where people come across our desks and they tell us that they have been let go, and the employer sends a termination letter that says that they've engaged in all of these forms of misconduct. Some of them might be true, some of them may not be true, and we have to go through it with that client or potential client to see whether or not these claims that the employer is making or whether those claims are valid. And if not, then we will help that employee obtain the severance that they're owed in that case. Okay, we're almost near the end of the session. We have a question here from JX2 on YouTube. What happens if an employer starts terminating employees that may be attempting to unionize? Well, that's an issue in and of itself. If you're attempting to unionize, it depends how far along into the bargaining process you're in, but that would be illegal. And if they're terminating you and you're not yet unionized, you'll be owed your severance pay anyway, in the same way of calculating your severance as we talked about throughout the session. We have time for one more question. It looks like we have another question from Dominic on YouTube. Does a company inherit your previous time at a job if they take over a job contract and hire you to stay on transition to their company? Good question. So yes, typically, if you're just transitioning smoothly from one company to another, your tenure will transfer with you. Your years of service working with the previous company will be recognized by the new company. Could be that the new company does not want to recognize your years of service, but they'll have to tell you that explicitly. If they offer you an employment contract where it clearly says that this is considered fresh employment with the new employer, your previous employment is not considered at all, your tenure is not considered at all, and you agree to that, then it could be that it's fresh new employment. But it would have to be clearly outlined. And very commonly, when one company takes over another, there is going to be a transfer of the tenure, as I said. So that's it for today. We got great questions, great topics. We're back with you again tomorrow with my colleague Lior Samfiru at 12:30 p.m. So if you have any further employment questions, please join his session. Thank you for joining us, and I'll see you again next time.